Great. All right, good afternoon, everyone, and welcome. I would like to call the meeting of the Committee on Council to order. I am Isha Collins, your Post 3 at-large City Council member, and I am joined by my fellow colleagues. To my left, we have our President Doug Shipman, Councilmember Andrea Boone, Councilmember Mary Norwood, Councilmember Howard Shook, Councilmember Liliana Batiari, Councilmember Byron Amos, Councilmember Amir Faroki, and Councilmember Jason Winston. Thank you all so much for joining us. I would like to make a motion to adopt today's agenda. Okay, it's been properly moved. I have a second by Councilmember Batiari. Please open the vote.
Batiari.
Oh, probably second by Jason Winston. So let me correct that for the record. Moved by Councilmember Liliana Batiari, second by Councilmember
The vote is
Jason
open.
Winston. It's not open.
Vote is closed. The agenda is adopted. 7 yeas, 0 nays.
Great. Thank you. I would like to make a motion to approve the minutes from our prior committee meeting. It has been moved by Councilmember Liliana Batiari, seconded by Councilmember Amir Faroki. We will now open it for a vote.
Vote is open. Vote is closed. 6 yeas, 0 nays. The minutes are approved.
Mark. These are laid out differently. Am I following this one or this one?
That one.
Okay, all right. I'd like to move forward item E on the agenda, the election of the 2025 Committee on Council Vice Chair. I nominate our former chair of this committee, Liliana Batiari, to serve as my vice chair for the 2025 council year. We will now, do I need to? Sorry.
Technical difficulties. 1 second.
Okay, give me 1 second.
Got it? I can distribute them right now. What we have.
Okay. All right, sorry about that. We have a technical difficulty resolved. I would like to nominate Councilmember Liliana Bakhtiar to serve as the vice chair of this, of the committee. And thank her for her service as serving as chair last year. I move to designate Councilmember Liliana Bakhtiar as a vice chair. Do I have a second? Second by Councilmember Jason Winston. Thank you so much. Will please now open it for a vote.
Vote is open. Vote is closed. 7 yeas, 0 nays. Councilmember Bakhtiari is the vice chair for the 2025 Committee on Council.
Great, thank you so much. Looking forward to our collaboration together, Liliana, to do some great work on this committee. So thank you so much for your leadership. So colleagues, the next item on the agenda is our 2025. Okay. Alrighty, I would like to make a motion to adopt the full council agenda. Okay, it's been properly moved by Vice Chair Batiari. Do I now have a second? Second by Councilmember Amir Faroki. Please open for a vote.
Vote is open. Vote is closed. 7 yeas, 0 nays. The full council agenda is adopted.
Thank you.
brings us to the goals and objectives.
Great. Now we will, colleagues, the plan is to adopt our 2025 goals and objectives at our February 17th meeting. I ask you to please send your recommendations to Mr. Overton. He'll collect our suggestions and we will finalize our goals and objectives at our next committee meeting. Now this brings us to our public comment portion of the agenda. When I call your name, please approach the podium and you will have 3 minutes with us. The only person I have is Mr. James Martin. Mr. Martin?
Yes, thank you. Jim Martin, resident of Berkeley Park, chairman of Neighborhood Planning Unit D. I'm here to address you with regard to the pending legislation about the Inspector General's office. I emailed all of you over the weekend to express my disgust and dismay over both the content of this legislation and the process by which it has been moved forward. There are numerous problems with the proposed legislation, which is probably not salvageable, and with limited time, I will focus on one, the new limitations on third-party subpoenas. Since we seem to prefer hypotheticals over actual facts in these discussions, I invite you to consider some future city council that has just approved a rezoning that allows a local mobster to construct a strip club between a preschool and an orphanage. Subsequently, staff members for several councilors approached the OIG and assert that they were privy to bribes being accepted directly from the applicant, to telephone negotiations for further bribes to be funneled through third parties, and for a bone marrow transplant from one of the applicant's employees to a counselor. This, along with other evidence, might lead OIG to seek subpoenas for financial, telecommunications, and/or medical records, which could easily yield evidence of wrongdoing. Under the proposed changes, OIG would be required to notify the targets of these investigations of her intent to seek this information, thereby offering ample time for them to fire the whistleblowers involved and portray them in the future as disgruntled former employees, to intimidate the remainder of his or her staff under the threat of further firings, and to destroy physical evidence and concoct a plausible story as to how all of this is simply an innocent misunderstanding. I don't see how that new system is in any way superior to the system that we already have. In fact, I see many ways in which it is vastly inferior. And so I would invite you to delete, at the very least, those revisions in the ordinance that you are considering. Thank you.
Thank you so much, Mr. Martin.
Madam Chair, if there are no more speakers, that brings us to the legislative portion of our agenda, starting with communications and resolutions. Item number 1, 25R3089, a resolution by Councilmember Andrea L. Boone appointing Mr. Christopher Brown to the Atlanta Citizens Review Board for a term of 3 years, said term to begin upon approval of this resolution and for other purposes.
Move approval. It has been properly moved by, thank you so much for the work, Councilmember Boone. It's properly moved by Councilmember Boone, seconded by Councilmember Battiari. Mark, is there anything else? Don't read it? Okay.
Vote is open. Seven yeas, 0 nays. The item carries.
Thank you.
Madam Chair, that brings us to papers held in committee.
Thank you. So my colleagues, before we get to the IG legislation, I wanted to make a quick note about 24-0-1684, which is the amended ordinance by Committee on Council to establish the salaries for the mayor, council president, and members of council for the purpose of term offices beginning January 2026 and for other purposes. And as a reminder, this legislation was previously amended to reflect the following salary adjustments for the mayor, council president, and member of council for the term beginning in 2026. And respectively, the amendment states that the mayor will earn a salary of $236,000 $236,865. Council President earns a salary of $103,250, and members of council earn a salary of $99,930. We will continue to hold this paper for one more cycle to allow for the appropriate advertising period in the county's legal paper pursuant to Section 2-306A2 of the City of Atlanta Code of Ordinances. And so with that being said, we'll be taking a vote on this item at our next committee meeting on Monday, February the 17th. So just wanted to make sure you knew while we were, that paper was held one more week, one more committee meeting. And so that brings us to item 25-01009. Colleagues, you should have received an email from Mr. Overton before the meeting, and also we sent an email last night with the most recent substitute of this item. Hard copies were provided to you as well. Mr. Overton, can you please read the substitute caption for the record?
Yes, ma'am. This is item number 3, 25-01009. An ordinance by council members Howard Shook, Marcy Collier Overstreet, Mary Norwood, Andrea L. Boone, Dustin Hillis, and Byron Amos, as substituted by the Finance and Executive Committee. An ordinance to amend the Charter of the City of Atlanta, Georgia, 1998 GA laws, page 4469, ex sequitur, adopted under and by virtue of the authority of the Municipal Home Rule Act of 1965, OCGA Section 36-35-1, et sequitur, as amended by amending Part 1, Charter and Related Laws, Subpart A, Charter, Article 3, Executive, in accordance with the recommendations of the City of Atlanta Temporary Task Force, charged with reviewing the processes and procedures of the Office of Inspector General, the Ethics Office, and the Governing Board of the Office of Inspector General and the Ethics Office, regarding the authority, oversight, and the clarification of respective roles and responsibilities of the OIG and the Ethics Office, and to create separate governing boards for the OIG and the Ethics Office and for other purposes.
Thank you so much. And so, as you all know, with this substitution, this was also incorporates the changes that came from not only the continuing conversation with the task force, but also our work session that we held in conjunction and with collaboration with the Finance and Executive Committee, chaired by Councilmember Howard Shook on last Thursday. And so this substitute reflects a few items, as you may see, pursuant to the feedback regarding the actual breakdown from the separating the OIG office and the ethics office into two separate entities. Each one of those entities will have their own governing board, additional pieces in terms of the opportunities for employees in terms of giving testimony, turning over property. There is also the limitation in terms of the third-party subpoena and a few other items. I would like to open it up to see if there's any discussion on this substitute, and we also have some additional context that'll be provided by the law department as well. I'll start from the left, if that's okay, and then work my way around. But do we have? Okay, we could do it either way. So let's do this. Let's have the discussion and then make the motion to bring. Okay. But we can make the motion to bring forth the substitute since we know this is the most recent version, and then we'll open it up for discussion. Okay, so I have a motion to bring forth the substitute made by Vice Chair Battiari and a second by Councilmember Howard Shook. We will now open it for a vote.
Vote is open.
Okay.
Vote is closed. 7 yeas, 0 nays. The substitute is before the body.
Great, thank you so much. And so now we'll open it up for discussion on this substitute. So I'll start with Councilmember Boone. Oh, sorry. Yes, Councilman Shook, my apologies.
All right, I'd like to begin by, asking for law to remind everyone, again, what the timeline is and what the process is, that for deliberation, and then also to walk us through the changes in this latest iteration, understanding probably not many people have had a chance to see it as of now.
Yes, good morning. Amber A. Robinson, City of Atlanta, Department of Law. Because this is a charter amendment under the state's Home Rule Act, it requires 2 adoptions by consecutive meetings of the full council. At this point, it has not had 1 adoption thus far. And so should this committee vote to move forward the legislation for consideration by full council, at that time, the full council will have an opportunity to adopt the legislation for the first time. Thereafter, the full council may refer the paper to FEC and Committee on Council for another cycle of committee consideration, which would be the week, that will be during next week. Following that, if it is approved or is voted to be moved forward by each of the committees of purview, the full council will have an opportunity to review, discuss the item for final adoption in the full council meeting to occur 2 weeks from today. At that time, if the full council votes to adopt the paper, then it will be sent to the mayor for approval or veto or approval pursuant to operation of law.
All right, thank you. And did you want to walk us through the current iteration or what's new in the current iteration?
Yes, Patrice Perkins Hooker, the actual city attorney. We have incorporated suggestions and requests that came from council members as well as ethics officer when and then points that were raised in the work session that did not violate the law. So the items are in colored ink on the paper that's in front of you. Some of them I'm not going to go through because they're just technically changing the names of governing board of the Office of the Inspector and Ethics Committee. A lot of those are just deleting it down to, again, just one. A lot of the newer changes are to add clarification. And I'm going to start with the first one. The first clarification modification is under Article 8.01, Section E, and it's subpart A. And that is added a pretty large chunk that says, should any applicable City of Atlanta internal processes and procedures cause delay in the surrender of property, such process or procedure shall be communicated to the Office of Inspector General in writing, and such communication shall detail the internal process or procedure causing the delay and provide an estimated date by which the property shall be surrendered. That section basically is the section that requires the city to provide the information that is requested from the OIG from an employee. The next section, the next page of that just adds software or other technology. There was a request to just clarify that the fact that they could do the request from the AIM department in any version of that, rather than just dealing with experts alone. They can do some things electronically. The next major change from the work session and clarifications thereafter from council shown on the, wish we had page numbers on this, that made it easier. It's in subpart B, and I guess it's 8B, where it says that while criminal conduct may result in criminal prosecution and the imposition of criminal penalties, statements provided during the interview shall be considered compelled, and that is a legal requirement, and we deleted reference to the actual Supreme Court decision that made that legal point clear. Then the next issue that was an insert or modification is under section 8-102, whereas the governing deals with the governing board of the Office of the Inspector General, and it defines good cause. There was already a provision in section C4 that says upon removal of the member for good cause by the majority vote of the board, and a definition said good cause may consist of, but is not limited to, sharing confidential information regarding investigations, using information gleaned from investigations for personal gain, or to influence investigations and/or a failure to otherwise fulfill their duties as a member of the board. There were changes in on that same page in subparagraph E1 that changes the terms from a 1-year to a 2-year term. But the vice chair is still at 1-year terms, just in case there is some need to replace the vice chair in between the terms of the chair. Then a concept with regard to changing the number of members was decreasing the number of people required to vote at a particular meeting, and down from 6 to 4 because there was a change in the number of the members from, I think it was 7 to 5. And so if you keep turning through little sections, you will see the number of those members of that board will be subsequently covered in another section, and we needed to make certain that provision was reflective of that. And then under H, which is section 8-105, Inspector General of the City of Atlanta, section 8, we deleted a reference about providing the written updates and said that would be just dealt with by their board as they requested them. And so that reference was deleted as a result of the workshop. And then we added under section, next paragraph, section 8-106, it was section 4B8, inserts dealing with receipt of a complaint via an intake system, and that change was made in both code sections, Article 8 and Article 9, dealing with the Ethics Office as well, to make certain that they were already charged with creating an intake system, and now this allows them to get the report via the intake system. On the next page, we deleted sections that dealt with having an obligation to reference a statutory site in the actual complaint, and then deleted the sections dealing with the opportunity for the Inspector General to reevaluate the position in the response time frame. On the next page, we added that the response can be made by video, but if it's a video, it will be taped and inserted into the record. Then we added the statute of limitations, which already exists, of 2 years on the initiation of any complaint. Then the next several pages were already the deletions of the previous ethics office. And then in Article 9, we incorporated comments from the ethics officer with regards to just clarifications on various sections in here. Incorporating a duty to cooperate is the first one, and then in accordance with this section deals with the access to public records. And then under section 9-101, subpart E1A, we had an entire block dealing with the jurisdiction, which is one of the issues that was requested by Madam Chairperson to deal with the jurisdictional concerns. The jurisdiction of the Ethics Office, they have the jurisdiction to access property and any related data should any applicable City of Atlanta internal processes and procedures cause delay. That same thing we talked about before. They have to be able to specify what is the cause of the delay and how that's going to work out. We also incorporated the software or technology additions in sections 2, subpart D. We also, in the next major change under section 6B, an insert was made: while criminal conduct may result in criminal prosecution and the imposition of criminal penalties, statements provided during interview shall be considered compelled, as they are under the law. The next sections deal with changing words just to ethics board rather than the governing board of the ethics office. We inserted the good cause standard in there as well as requested. And the next several pages had no change except the ethics board changed, ethics, governing board of the ethics office, just the ethics board. And then we deleted the requirement that was reflected in here about providing updates. Again, the boards will indicate how often they want to be provided reports and the nature of those reports. I need to find the 6. And then there was a suggestions, the same things that we talked about the video response. And those were the changes that were made as a result of the requests from council member and or the work session and the ethics officer.
Thank you so much, Attorney Perkins Hooker. Okay, so with that being said, I wanted to open up for discussion because I do know there has been some concern and feedback about the substitution and some of the additions and omissions. So I would love to open it up to my colleagues on committee to start. Councilmember Bottari.
Yeah, thank you. I'll actually leave my comments fairly brief. Looking forward that some of the big ones that we were talking about in terms of removing council and the mayor from being able to, from the board, which is a really big one. I'm pleased to see that several of my amendments, almost all of my amendments were adopted, and I do appreciate, I want to give thanks to everyone who worked on that and for our work session. Absolutely, we've made this into a stronger bill, but I also have more digging in to do and many more questions, and I'm still learning. So I'm looking forward to the time and continuing to carry on conversations with each of the offices involved. So, but thank you for adopting a majority of my amendments.
Thank you. Councilmember Faroki.
So procedurally, we have yet to adopt the substitute, is that right?
Yeah,
We have not voted to adopt the substitute, correct?
no, we made a motion to,
Or we did that already.
You've substituted the original text with the substitute.
Brought it
Yes.
forward. So, okay.
It's not adopted as substituted.
Yeah. Okay. Do we need to adopt the substitute before considering what to do with it?
No, it's been,
Okay, fair enough. Right. My sentiments are similar to Councilmember Bakhtiari, and my posture today is we should hold it because we're close. We're getting closer to, I think, a mutually agreeable solution. And so I'll put a motion to hold on the floor.
okay. Motion to hold on the floor. Is there a second?
I'll second it.
Okay, it's been properly seconded by Councilmember Shook.
So I do have an amendment I'd like to offer,
Okay,
but perhaps it would be better if first,
it's not in order now, so
motion to hold.
we'll need to entertain a motion to withhold the hold. Is that what it is?
If it helps, I can withdraw the motion to hold, so Councilmember Shook's
Yes.
amendment. Yeah, so I will withdraw my motion to hold.
Great, thank you. Do I have a second? Or no? Okay, great, thank you. So now, Councilmember Shook, you can now entertain your motion to amend, and on what basis?
okay, thank you. And law will correct me if I'm trying to amend the wrong section here, but it's section 8104, subpara A, which currently reads the governing board of the Office of Inspector General consists of 5 members, all of whom, et cetera. I would like for that to be changed to 7. And And then the second half of the same amendment then is to take subpara B, which are the constituent members, and restore the League of Women Voters as well as APAB.
All right.
So that's my amendment.
So for clarity for the public, for the motion to amend is referring to section 8-104, which is the governing board of the Office of the Inspector General, and restoring the language for the board, the governing board of the Office of Inspector General to consist of 7 members, which is subsection A. Moving to subsection B, restore subsection B5 and B6, which states that the appointments to the board shall be made with a designee from the Atlanta Fulton County League of Women Voters, who may nominate 1 member, and the Atlanta Planning Advisory Authority, who may also nominate 1 member. Do I have a second for that motion to amend? Second by Tiara. We will now open it up for a vote. Oh, excuse me, is there any discussion? And while I do want to, as we're talking about that, what I do want to also convey to the public that has been resolved, the removal of the full city council may nominate 1 member, that has been eliminated from the new substitution, and the mayor may nominate 1 member has also been eliminated from the substitution. And also wanted to just make it clear that with these changes and even the original, there was not any sense that this entire governing board was fully appointed by the mayor. I do want to clarify that because there was a lot of I know a few of us received a couple of calls on that. So with that being said, those 2 provisions have been removed from this substitution. League of Women Voters and APAT will be restored, and the governing board for the Ethics Committee for the Office of the Inspector General will be restored back to 7 members. Any additional discussion? We will now open it for a vote.
Vote is open. Vote is closed. 7 yeas, 0 nays. The item is amended.
Okay, thank you. And then just one other request before I relinquish. There's been a lot of discussion around voluntary versus compelled testimony. I think that is very imperfectly understood. It's dreadfully important. I know I need to keep educating myself on the differences. And so I would love to hear the law department opine on the difference between those 2.
Yes, Patrice Perkins Hooker, City Attorney. We have had a couple of opportunities, and the President of the City Council has asked this question before too, to discuss this both at the workshop session and other places. And what it boils down to is we have compelled our employees, you all have, in the original legislation, to participate with in fact, to cooperate fully with the OIG in their investigations. The fact that we compel them means that we can take disciplinary actions against them if they fail to cooperate with them. And so you all created that before you started going through the rest of the text and the providing powers to the OIG to go ahead and interview employees. And that's consistent with several modes of operations with regard to OIGs having the ability to interview staff. When they are interviewed, those interviews do not go forward in any criminal investigation. Those interviews become a part of the file for the administrative investigations. That information gleaned from those interviews goes into the OIG's report and the recommendations, and those recommendations, according to this legislation, are to be sent to the mayor and the city council and the department head that may be involved in the particular investigation. The Supreme Court years ago, not when we dealt with this legislation, looked at situations involving the utilization of police officers' statements against them from internal investigations and whether or not those statements could be used against the person in a subsequent criminal investigation, and they made that decision to not do that. Then there were a series of other cases applying that same concept to municipalities and to other types of investigations undertaken on an administrative basis. We wanted to make certain that issue has been raised before numerous times because the OIG's practice before January, I don't know about now, but the OIG's practice prior to January was that the employees were invited to come to do an interview. They were given a form that says voluntary statement, and then those employees had to sign the statement, and then they were not told, and that was what was conveyed to the task force, not to me, was conveyed to the task force by the OIG, that they are told that those statements could be used against them in any subsequent criminal investigation if criminal activity arose. In the law before you, in section 8-101E8, currently, 8 in the current one, before any of these modifications, under Article 8-101E, subpart 8, which is on, looks like it's on page 5, 6, because the first page.
That's where it is correct.
The current law codifies this, and it's actually 9 now because of changes you all have proposed. It says, in addition to the obligations described in this section, it shall be the duty of every city official or employees and officials and employees of city outside contractors, vendors, and agencies to cooperate with the Office of the Inspector General, and in it currently, before your changes, or the Ethics Office, regarding any investigation or review initiated pursuant to this article, by answering questions and/or make sworn statements concerning an investigation or review initiated pursuant to this article, when directed to do so by a duly appointed representative of the Office of the Inspector General or the Ethics Office. Officials and employees will provide all relevant information and answer all questions honestly, completely, and to the best of their ability. An official or employee's refusal to cooperate and provide sworn statements, answers as required by this subsection shall be considered a violation in accordance with the subsection 1 of this section. And because you compelled them to participate, when you created this office, those statements cannot be deemed voluntary as a matter of law. And so, no, we don't want any employees being confused of saying, okay, I'm signing this statement saying I'm making it voluntarily when they're already compelled to do so. And the law is clear on this, the interpretations on it are what has caused the need to make certain that we protect employees and make certain that we mention them as being compelled, because they are compelled. Any other questions on that issue?
Yes, Madam City Attorney, I do need to get some clarity on this letter, a notice to cease and desist. Will you please explain that to me?
Okay. The cease and desist letter was issued because of what we discussed and discovered, at last Thursday's work session. I had received some subpoenas, literally, I don't know if it was that day or the day before, that were part of a request I made to the OIG of what type of subpoenas had been issued, because there was a lot of scuttlebutt about the nature of those subpoenas, and I didn't have any. So I asked for them, and I did get several of them. And in receipt of those, I noticed that there was a statement or disclaimer placed on the top of the form that indicated that the bank was not to notify their customer. The reason they put that on there is because normally under the law, a bank is obligated to notify account holders and customers under the state banking law. And I provided you a cite to that. They were obligated to provide that. And so when that office was using those forms, I told them to cease and desist adding that disclaimer on top of the subpoena, so it could be in compliance with Georgia law, because I'm actually afraid that a lot of the people, now we know that the subpoenas were issued to over 40, maybe over 50 people. I'm missing some from her office, but I know I'm gonna get them. I know that we're missing the total number of people who might bring charges against the city for violating their privacy rights. And so I had to stop it so we won't continue to go forward. I did receive a response from the Inspector General, and she said that she had followed up after the meeting on Thursday when it was brought to their attention with some standard operating procedures that would be, I think she reported as being rewritten to address the needs with regard to these subpoenas. So my hope is that once her board approves those, that we will, going forward, we will not have any more risk of liability. But that's what the cease and desist was written for. Did I address your question, Councilmember Bowman?
Yes, thank you.
I have a follow-up question to that, Madam City Attorney. So again, the cease and desist does not eliminate her authority to issue the subpoenas. She just has to give notification to third party, notification, but also allow those individuals to file the formal motion to quash, which is also part of the legislation. Is that correct?
That is absolutely correct.
Okay.
We were not stopping her subpoena power or hindering that power. We were just making certain that power be utilized in compliance with Georgia law.
Okay. That it be utilized in compliance with Georgia state law.
That's correct.
Okay, thank you. Any other questions on that piece? So,
Yeah, Mr. Shook.
oh, sorry, sorry. Councilmember Shook.
No, that's right. I frankly haven't had time to digest that latest development yet. So getting back to compelled versus voluntary, I'll admit yet again, that's something I keep stumbling over. So let me ask one follow-up question about it. Am I right by putting it in layman's terms that if I receive an invitation to be interviewed by the IG or ethics, the extension of the invitation is by itself, in terms of settled constitutional law, a compulsion?
Yes,
Okay.
if you're the employer. And it's because you have it in your legislation that they are compelled to cooperate.
It's in the legislation.
It's in the
But
legislation.
you can change the legislation.
Oh, yes, you all created this legislation. You are
Yeah.
flexible.
I'm sorry, well, and I did.
Okay, Council President Shipman was over here having a conversation, and what he said was true. And that is, your legislation compels the participation. And because it compels the participation, that's what makes it a situation where the employees are not providing voluntary statements. If you decide that you want to amend your legislation and say that it's not compelled, the employees would not be subject to that same interpretation. But we got some other parts on that.
Yes, just to piggyback on that, it is true that you all, as the legislature, could amend the charter to try to make it voluntary. However, it is not adequate simply when dealing with city employees, as opposed to contractors or possibly other people, but as dealing with city employees specifically under settled constitutional law, it would not be adequate just to say these are voluntary, because as currently set forth, the OIG cannot provide a adverse employment action against any such employee. Adverse employment actions are provided by the commissioner or appointing authority of any such employee. So an extra step would have to be taken, not only to say that the statements are voluntary, but to say that under no circumstances may any employee suffer any adverse employment action in any way, be it suspension, dismissal, any sort of adverse action concerning assignment for a failure to cooperate with the OIG. All employees employers have to be it's told explicitly that no action can be taken against an employee for them exercising their right not to cooperate with the OIG. So it has to be explicit that nothing can happen to an employee for their failure or decision to not cooperate. That would be different than every other internal investigative agency in the entire rest of the city, be it any department, be it any other like HR or ACRB. That would be different than any other one. And there might be consequences concerning that.
In addition, the point is, when you all created this office, you designed it to be an administrative watchdog, that you needed the employees to cooperate. And so I think that's why you did this in 2020, but way before we got here. So if you make it that they don't have to cooperate, you're not going to get anybody to cooperate. Nobody's going to want to take a chance to do that, not knowing what's going to happen to them.
All right, I appreciate that, and all this kind of underscores, my hope that we're going to have more time to discuss this, because to me, this is the most important sort of unfinished piece of business here. There are others, but this is, I think, really central. And look, I agree with everyone when it comes to one thing. We've all had a snoot full of this. I've never looked forward more in my life to taking up the tree ordinance than I am today. I think we're real close. We've all worked so hard, us, law, the subject offices, the public. I mean, we've all prostrated ourselves over it. I think probably we're suffering from Stockholm Syndrome as a result. But that concludes my comments for right now. Thank you.
Thank you. I do, Councilmember Faroki and then Councilmember Norwood.
Yeah, motion to hold.
Okay. Okay, give me one, I have one follow-up question, just one quick. I understand. I have one follow-up question about that, because I think it's important, because that is one of the pieces with the volunteer versus.
You didn't approve the amendment.
Yep.
You did? You did vote to approve the amendment?
No, you're in.
Councilmember, should we need to approve the amendment and then entertain a motion to hold, if that's okay? Just one quick question for clarity on the voluntary and compulsory, the compelling. If we move to if we change the legislation, for the statements to be voluntary, what authority or what power does the Inspector General have to get the information that she needs? Is that an increase in subpoenas? Is that an increase in motions? Like, what does that look like for, and not just this office, but any standard?
So the ability of the Office of Inspector General to get information from means other than employee statements would be unchanged. However, any employee statements, rather they be by subpoena or otherwise, would, if they're voluntary completely, they would remain voluntary, and there would be no ability for the Office of Inspector General to glean any information that is needed to be obtained through employee statements. They would be foreclosed from being able to get that information unless the employee voluntarily provided it.
Okay, thank you. So we will now entertain, Council, did you want to say anything, Council?
So here's what's happened. They have record that the amendment was adopted, that the amendment was passed,
Who is they?
the staff. So let's just vote again.
Yeah.
Just to make sure.
Absolutely, yeah, I was going to say who was they and what was the voting record, because we didn't. So let's go ahead and entertain a motion to approve the amendment.
It's already moved. So
Okay.
all you have to do is vote.
We'll now open up for a vote. This is to approve the amendment to restore back the League of Women Voters and the Atlanta Planning Advisory Authority to the Governing Board of the Office of Inspector General, moving that legislation back from 5 back to 7, and approving the elimination that the mayor and the city council will not have a nominee on that governing board. That's the only amendment on the floor. We will now open it for a vote.
Can we repeat the motion during the seconder, please?
The motion to amend?
Move during seconder.
Councilmember Shook made the motion. Councilmember Bakhtiari seconded the motion.
Vote is open. Vote is closed. 7 yeas, 0 nays. The item is amended.
Thank you. Okay, now we have on the floor a motion to hold.
Ask if there's a second.
Is there a second? Seconded by Councilmember Councilmember Bakhtiari. We'll open up for discussion. Councilwoman Norwood?
Yes, and as you all know, I'm not a member of this committee, but I would hope that we would move it forward, and I would hope that we would have another 2 weeks to make the final modifications to it. If it were to be enacted today, and that was it, I would not be in favor of moving it forward. But I believe that we have made tremendous progress, and I would like to see it get to council. We can then have 2 additional weeks until the 17th to do whatever amendments and whatever revisions, and then vote it. That would be the second time it would be voted on as a charter amendment, and that's when it would take effect. So that's my request for your consideration.
Thank you. Councilmember
Yes,
Boone?
I would like to make a substantive motion that we move it forward today.
It's not in order.
Yep,
This either has to be moved, this either has to be.
yes,
Voted down.
exactly, yep. So, absolutely. So, thank you so much for that, Councilmember Boone. We would need to entertain the motion to hold on the floor first, and then entertain any follow-up motion from there. The discussion in terms of holding will, Councilmember Winston?
I mean, this is one of those, I'm truly torn on this. There's been a lot of hard work behind the scenes to get us to this point. Council members have truly been working to perfect this and make it better.
Either has to be voted down.
I feel like the process should continue to move forward. There is another committee of purview that has an opportunity to discuss the changes that have been made. That would be the Finance Executive Committee, should it continue through that process where it goes to full council and back to FEC. And I think what the changes that I've seen so far have been substantial enough that I think it deserves the right to continue moving forward, that we'll have another 2 weeks to be able to continue discussing this, seeing if the other committee of purview has an opportunity to address their concerns as well, and keeping it here, I think, prevents that from happening. So I'm in support of continuing the process, because I feel like giving council a deadline will help us get to the end game sooner than rather than later. Thank you.
Councilmember Bakhtiari?
Thank you. We absolutely have made, I want to second Councilmember Winston, we have made tremendous changes. I believe in this paper, I believe in this office, why I submitted so many amendments and have been working on this so diligently, as have my colleagues up here. I have a duty to my constituents to make sure they're informed of the facts. Right now, they are not, and I owe it to them to vote to hold today. And yes, everything you're saying about advancing, correct. My constituents don't know that. So I have to take the time to inform them of the facts so I can get them to understand how much work has been put into this. So that is why. It's not because I don't believe in this paper. It's not because I don't believe that we're headed on the right path. I absolutely do. But I need time. I need this next week to really educate my constituency on where we are. That is all. Thank you.
I appreciate everyone's comments. We have done a lot of great work within the last week to move this legislation forward. I know there are just a couple of low-hanging fruit that council members have really emphasized. And with that being said, if we were to hold this February 17th, our next committee meeting, we will need to land on a final version. I think we're 90% there. So with that being said, I will now open up a vote on the motion to hold.
Vote is open. Three yeas, 4 nays, the motion does not carry.
I didn't get a chance to.
Back to the motion to adopt.
Motion to adopt.
No, I'm saying I didn't even get a chance to vote.
I'm sorry?
Yeah, that's all right. It had me as the mover.
Well, you were initially, that's what was said, correct?
Yeah, I don't know. Yeah, okay. Well, I mean, I know I didn't vote, so we'll leave it. So the motion to hold fails. So we will move forward with the motion to
Adopt.
adopt the substitute. Sorry?
Adopt the legislation as substituted.
The motion that was made by Councilmember Boone was to approve the substitute as amended.
Approve as substituted, on substitute as amended.
Cool. So what was my vote then? Liliana was.
On the whole, so we have, you guys can move it. We can change that in the minutes.
I mean, I think the minutes should.
And then what was your like to vote?
I just want to make sure that the record really reflected who made the motion to hold and who seconded the motion. So the motion to hold was by Councilmember Faroki, and the second was Councilmember Battiari. Yeah. So with that being said, we will now entertain a motion to approve the substitution as amended.
Boone.
Motion is to approve as substituted.
Yes, So it's been properly,
Boone.
it's been properly moved by Councilmember Boone. Do we have a second?
Second.
Second by Councilmember Amos. I'm sorry, any discussion?
Madam Chair, can we open the vote?
Any discussion, any questions? We will now open for a vote.
Vote is open. Vote is closed. 5 yeas, 1 nay, 1 abstention. The item is approved on substitute as amended.
Okay. Huh? Motion to, do you want to? Okay. Okay, yep, so we will go ahead and move forward. Thank you, 5 yeas, no, 1 no, and 1 abstention to move forward with the substituted adoption with the amendment. All right. Mr. Overton, is there anything?
No, Madam Chair, that concludes our legislative agenda for today.
Great, thank you so much. Colleagues, we will continue to identify give me 1 second. We'll continue to identify the vacancies that are of crucial importance and follow up on those vacancies to fill. And so we're currently focusing on the Atlanta Commission on Fatherhood, Men and Boys, and the Small Business Advisory Committee. Mr. Overton, do we have any additional business for today?
No, ma'am, we are
Thank you all so much. We stand adjourned.